Okay, hi guys, this is going to be an introductory lecture into tort law, and we'll basically go on to talking about negligence in this because that's going to be the focus for the several next lectures which follow. So there are several principal torts such as negligence, nuisance, defamation, assault, battery, false imprisonment. We'll move on to intentional torts later on. However, for the first couple lectures it will be talking about negligence, how to establish it, all the factors that come with it. So, with negligence, to establish it, you need to find 5 different things. You need to show them to different standards in different conditions. So, firstly, we start with duty. So, this basically talks about a duty of care. It says that the defendant owed a duty of care to the claimant to prevent such an action from occurring, so harm that they've suffered or harm of that nature. So as a doctor, you owe a duty of care to your patients to look after them, provide reasonable care to them. Then once you've established that there was a duty of care in that position, you have to go on to talking about breach. So was that duty of care breached, such as you've gone to the doctors and they've sent you away without even looking at you, even though you're entitled to them looking at you? That would be a breach there. So usually from that breach, there'll be a damage or a loss that occurs. So we have to establish that that's happened and that is a direct cause from the breach above. Then once we've established the duty, the breach, the causation, we go into talking about defences. So we return to the defendant there. So can the defendant show that they had a legitimate excuse or reason for their behaviour? And then lastly, we look at remedies. So the claim's been successful or certain aspects of it have been successful. So if there's 2 different claims for psychiatric harm and physical injury, the physical injury has been successful with psychiatric harm. You look at what remedies are available depending on the harm which has occurred. So now we're going to look at the historical development of duty of care. So a really good case to look back to is Donahue and Stevens. I think a woman bought her friend a drink. It was a ginger beer, something like that. And inside it was snail. I think it was like remnants of snail. It wasn't a whole snail, but that's irrelevant. What I'm mainly going to do in these lectures, I won't go over the facts a lot, but I'll give you what that case exactly stands for, what was important from it. So she wouldn't have been able to sue in contract because she wasn't party to the contract. Her friend bought the drink from the cafe owner. She wasn't in that. So tort law basically shows that there isn't a contract there, but the relationship exists otherwise. And in this case, Lord Atkin developed the neighbour principle, which he said reasonable care must be taken to avoid acts or omissions which you can reasonably foresee would injure your neighbour. This basically says your neighbour is all the people who would be affected by this product, action, whatever is in question. And reasonable foreseeability plays a big part because, as you'll see later, if you can't see this particular damage happening, how can you act against it? How can you prevent it? So another case which is quite old, it's from 1970, it's Dorset Yard and Home Office. So there was a juvenile prison. They managed to escape due to the negligence of the guards, and then they went out and damaged all these yachts. And the question was, are the Home Office liable for them? And it was found that they were, because they're in control of those third parties, the juveniles, and they could foresee that if we don't do our job properly and they get out, they will go on and do further damage in the community. Okay. Lastly, there was the Anne Merton London Borough Council case of 1978. This provided a 2-stage test, however it was abandoned because it had a lot of problems in it. If you focus on essay questions, I'd say go and read about it a bit more, see how it was applied and what issues were raised with it. But current law, we don't look at it anymore. It's been abandoned. Okay. So then we look at the CAPARO criteria. So this case was basically the law that's been used up until 2018. This has been changed by Robinson and Chief Constable of West Yorkshire. So it's no longer the current law, but it's important that you all remember all the cases which follow on from this, they're still good law. So in CAPARO and Dickman, they produce 3 requirements. They use this in novel situations. Novel situations are where you don't have precedent to rely on. This is a completely new situation. The law has to be developed in a new way. So the first requirement was that there be reasonable foreseeability. Second, that there be reasonable proximity. And then the last limb is that it must be fair, just, and reasonable to impose a duty of care. This third limb is basically what's no longer applicable from this. Robinson's taken this out. It's basically said you no longer have to consider this when making a decision, and we'll go on to discussing that later. So now we'll talk about foreseeability. It's quite a flexible test. It's open to be manipulated by the courts. They're able to interpret it in a way that different cases will achieve different outcomes based on what. So it allows them to prevent an unfair imposition of liability. So there's Attorney General Hartwell. So it was a probationary officer, and he had access to a gun. He went and he found out his wife was having an affair. He shot, I think, the guy who she was having an affair with. And then they brought a claim to the police saying that you owe a duty of care to the public to make sure that your officers only have a gun in access when they're able to. This is basically occurred from their negligence to not provide that gun. It was along those lines. And it was found that the police do owe a duty of care. You can only provide guns to officers which you can trust them with, and by giving them that gun, you've entrusted them to use it properly. Then we look at reasonable proximity. So this looks at various things, such as the relationship between the defendant and the claimant. So in Osmond and Ferguson, 1993, there was a teacher. He was very obsessed with one of his students. He used to basically harass him, follow him, and he ended up shooting his father and the child himself. The father actually died, and they contacted the police numerous times, and the court basically said that yes, there was reasonable foreseeability, the proximity was there, so that satisfies the requirement we're looking at now. However, they later said that it wouldn't be fair, just, and reasonable to impose liability because they were going against the police. And you can relate this back to Hill and Chief Constable of West Yorkshire. It's another case which basically argues that the police and public authorities have been provided with a blanket immunity. We'll go into discussing this later, whether it actually does exist, if it still exists. Okay. The second thing we can look at, was there an assumption of responsibility by the defendant in relation to the alleged tort? So for this we can look at Kent and Griffiths. So there was a woman, she was having an asthma attack. She called an ambulance. They said they were on their way, and they were quite close. However, it took very long to come. They kept calling them again, asking where they were. They reassured them an ambulance is on their way, and the ambulance took so long that she suffered such an extent of injury that they brought a claim against them. And then the doctor provided evidence that if she knew it would have taken this long, she definitely would have come before. This delay is the cause of this damage and harm that she suffered. So basically, by saying that there was an ambulance on the way, they've assumed that responsibility. They're saying, we are going to come, we are going to take you to the hospital, we are going to look after you. Okay. We can then look at the relevant type of harm. So in Vals and Evans, it basically says that a referee owes a duty of care to players. As the referee, you're there to ensure that reasonable safety is there for your players, that no one's going to be injured doing this particular job, and it's part of their job. That harm directly relates to their job. It's something that they were meant to prevent. That proximity is there. Lastly, we can look at the class of the people. So in Hill and Chief Constable of West Yorkshire, it was the case involving the Yorkshire Ripper. So they basically had him in custody. They released him because there wasn't enough evidence to say that it was him. They had to release him. And then he went on and killed again. So the mother of that woman brought a claim saying that the police owed a duty of care to prevent this happening to her child, prevent the murder of her child. They had him in custody. They shouldn't have released him. They allowed this to happen to her daughter. However, the courts basically held that there was nothing to signify that the daughter was at risk. There was nothing to say she's going to be the victim, and it would be way too wide a class to impose liability. They'd be responsible for every single female in that area, and that would bring in a floodgate of claims. So the court decided not to find that proximity there, and you can argue that it was the right decision because there was nothing to signify. If there had been something to signify he was going to hurt her next, then they should have provided protection to her or something like that, but you can't really find that in this case here. Okay, now we look at whether or not it's fair, just and reasonable. So when looking at this, they'd consider a number of factors, such as whether there would be a floodgate of claims if this was allowed, the insurance position of the defendant, if the defendant acts for the collective welfare, and also if it was an act as opposed to an omission. So in Smith and Littlewoods, they basically failed to protect from trespass, but they weren't aware that this risk even existed to them. So they didn't act in a manner, they omitted to protect from this trespass, but they weren't able to foresee it. But we don't really consider this anymore, as this has been abolished by Robinson. So in Robinson, it says that if there's precedent, use it. In novel situations, the law is to be developed incrementally and by analogy. And they say that you no longer need it to be fair, just, and reasonable to impose liability. It makes us all equal in the eyes of the law. So whether you're a public authority or an individual, you're held at the same standard. So in Robinson, they were going to arrest a woman, they were going to arrest a drug dealer, and they harmed an elderly woman in the process, in the street. And the court said you'd be able to foresee that this arrest wouldn't go down. Probably you should have taken these steps to ensure that you're not going to harm the general public in the process of this arrest, and they failed to do so. And it was irrelevant that they were the police. It was irrelevant that it was a public authority. We're all equal in the eyes of the law, and liability was found there. It's quite a new case, so I'd advise you read the judgment just to wrap your head around it. And it's supported by several cases. It's being used. It's one of those are in Sumner and Colburn, and then the second is in James Bowen. I've included all the citations for the cases as well, so that you're able to find them if you want to go and find extra information on these cases. So then we look at establishing a duty of care under Robinson. So they basically say, is there any precedent? If there is, you use that analogous precedent. If not, you look at something that's quite similar. So you look at a case that has many similar facts, aspects, and you build on from that. So if you change the facts of those cases to match this one, what would be the outcome? So then they say that is, it's the use of that. So if there isn't one, you have to find the closest thing that you can. It basically says, it's like when you're writing a book, you can't just make a chapter out of nowhere. It has to follow on and use all the information in those past chapters. Okay. So this is basically an introduction, and we'll go in and discuss all of these things later. So such as the duty breach, these will be discussed in a lot more depth, and all those videos will be made available as well.